Your Honor,
Best friends moment.
Yes, ma'am.
ready to do the resets.
Okay. Who's first, Mr. Schmidt?
1 second, Judge, I'm trying to pull up my docket. Oscar Bandit.
You say Hernandez?
Panda.
Banda?
Yes, sir.
Video's not real good here. All right. Oscar Banda, cause number CR 25-63 for pretrial. Go ahead, Mr. Schmidt.
Judge, we are set for pretrial. I've got some pretrial issues that I need to further investigate. I'm gonna ask if there's no objection, if I can have an additional pretrial setting.
No objection, Your Honor.
Thank you, Mr. Hernandez. How much time do you need, Mr. Schmidt?
I think just a standard reset should be sufficient.
All right, court recess, Mr. Banda, then for pretrial July 1st. $1:30.
Zachary Campbell.
Cause number CR 25-32, State versus Zachary Dale Campbell.
We're set for pretrial, Judge. I don't have any contested motions for Mr. Campbell. Should be ready to resolve it pretty quickly. So I'll just ask for a doc call setting.
All right, so I had notes here that Mr. Campbell was he in the Ellis County Jail?
He was, Judge. He was in Ellis County for a bond issue that occurred prior on something that was prior to this offense. So he's out now.
Okay, so he just reported to the Justice Center today?
Yes, sir. For
Okay,
court.
so our next setting needs to be 9 a.m.?
Yes, sir.
All right. You said no pretrial issues. Court sets Mr. Campbell then for docket call. Is that July 1? Okay, Mr. Schmidt?
Yes, sir.
All right, July 1 at 1:30.
At 9 a.m.
At 9 a.m. Yes, 9 a.m.
You can call.
No, I'm already know that's uncomfortable.
Who's next?
Colin Brown.
Warren Lee Brown, CR 25-67 and CR 25-66. Mr. Brown is set for pretrial. Go ahead.
No contested pretrial, setting for docket call on July 1st date.
All right, court sets Mr. Brown for docket call July 1st. Each case, 1:30.
I'm off the list. Huh? Potential. I'll be back.
Who's next?
Jimmy Collier.
Jimmy Dean Collier, CR 25-36 for pretrial. Go ahead.
No contested pretrial, judge, need docket call setting.
All right, court sets Mr. Collier for docket call July 1st at 1:30.
Matthew Hall,
Matthew Tom Hogg, CR 25-43, set for pretrial.
that's correct, Judge, no contested, we, setting for docket call.
All right, court sets Mr. Hogg for docket call July 1st, 1:30. Who's next?
Mason Hall,
Mason Edwin Ho, CR 24-233 and 234, FC 24-146. Set for docket call. Go ahead.
just a moment, Judge. Judge, could we have a final docket call on Mr. Hogue on July 1st?
Any objection from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Hogue for final docket call July 1st.
One second, Judge.
Yes, sir.
This is Roy Mitchell.
All right, this is cause number CR 25-23, State of Texas versus Roy Mitchell III. Sure that we're set for pretrial today, but Mr. Schmidt, you filed a motion to withdraw, is that correct?
I did, Judge. Unfortunately, I've had a good relationship with Mr. Mitchell, but given the nature of the conflict containing the motion, I had no choice. So I'd ask the court to rule on that motion and provide Mr. Mitchell with new counsel.
All right, the court is there any objection from the state?
No, Your Honor. Thank you.
All right, the court, having considered the motion, the court hereby grants Mr. Schmidt's motion to withdraw for the conflict stated. And the court will appoint the Honorable Jonathan Manning to represent Mr. Mitchell. We will reset this matter for pretrial hearing. Thursday, July 10th. That'll give Mr. Manning an opportunity to meet with Mr. Mitchell and get brought up to speed on the discovery. So any discovery that you have from Mr. Mitchell, you'll be able to give that to Mr. Manning, correct, Mr. Schmidt?
Yeah, that's not a problem. Basically, the DA's office. Judge, I'll say, yeah, but he still has the authority to deny us, even if the parties. All right, well, Mr. Manning will be in touch. Well, we do, yeah, but I don't need to resell, because he's not here. We could call Preston Wilson. He's in federal custody as far as I know.
Cause number CR 23-83, State of Texas versus Preston Mitchell Wilson, status of federal custody. Mr. Hernandez, you or Mr. Hartwell have any information about Mr. Wilson?
I do not have an update on that, Your Honor. My apologies. I did talk with Mr. Hartwell about it, just trying to remember that between that case and the one this morning involving the Pennsylvania prosecution. So I'm not sure what the update would be on this one.
Yeah, I think Mr. Hernandez is confused with that. Mr. Murray is in Pennsylvania. He's in federal custody. This individual was taken locally by, I think ATF agent Petrie was involved in that. So last I heard, he was in Henderson County, I believe, being held federally.
Yeah, no, Mr. Hernandez just stated though that he had spoken with Mr. Hartwell, not only about this case, but also the one from this morning. The
Oh, I got you.
case, trying to get brought up to speed. So,
I see.
all right. So this, what I'll do is I'll set this for a status on July 1st. But what I would like to do is get some kind of definitive answer on what we're going to do, because courts are being graded on how fast cases are being set and handled in the court system. So leaving this on a perpetual custody status is not good. So I'm going to set for July 1st. I'd like to have some kind of definitive answer from the state on whether we're going to bench warrant, whether we're going to proceed with the prosecution or dismiss the prosecution.
Yes, sir. Thank you.
Okay.
Yes, sir.
While Mr. Schmidt goes over the rest of his plea papers, can we do that emergency hearing on Mr. Bear?
Yes. All right, Mr. Baird, what I want to talk about with you is what is your attorney status? I know Ms. Tabraham has sent some forms out there, and at this time, you're not eligible for a court-appointed attorney because you own real estate and assets that have value and that prevent you from meeting the poverty guideline and the indigency status that's required for the taxpayers of this county to be obligated under the Sixth Amendment to pay for you to have a court-appointed criminal attorney. So surely you've been sitting in the Van Zandt County Jail thinking about your future and thinking about this case. What is your plan on how you're going to handle representation in this matter?
I don't own any property, Your Honor.
Mr. Baird, I've researched this issue myself, and I find in the Van Zandt County Appraisal District that you own 2 acres on one tract, and then another tract you own 6 acres. So I show that you own 8 acres of land.
That land is owned by Heather A. Atkinson, not me.
Is owned by who?
Heather A. Atkinson.
Well, it says it's owned by you, Walter L. Baird.
Yes, it was, but it belongs to her now. All that's been taken away.
Okay, so how was it taken away? Did you sell the land to her? Did you convey the land? How did that work?
My girlfriend, she said she needed it in her name so that she could try to get me bail, and then didn't get bail. I signed it over.
So you deeded the property to her?
Yes,
And did you file that in the real property records in the clerk's office to put people on notice?
I guess she has. I don't know. I haven't.
So do you have a copy of that deed?
No, sir. There should be one here somewhere. It was signed here in the jail.
Right, but did she leave a copy with you? Did you require a copy to be left with you?
No, they didn't leave one with me, sir.
All right, so Mr. Baird, what I need to see that you don't own property. And right now, the only evidence I have is from the appraisal district that says that you do own it. So I'm gonna order you to have this deed that you sign transferring this property to this individual, I need to see a copy of that. So I'm gonna order you to make contact with whoever has this deed and have them bring this to the court or bring it to the jail so that we can make copies of it, so that I can review it to determine if it is a lawful conveyance of property and therefore it takes away the assets, and then I can reconsider whether or not you're indigent. Does that make sense? Okay, so how soon, how quickly do you think that you can get that for the court?
Yeah, this week.
This week? Okay. And do you want to bring it directly to the court, or do you want to have them bring it to you at the jail?
Yes, well, which is best for you?
Probably best would be to bring it to my office at the courthouse. And then we can always make a copy and send it to the jail and put it in your personal matters. Okay, so tell them we need that. The sooner the better, okay? And then once we get that, then we can come back together and we can talk about it, or I can review it without us having a hearing, okay? All right, thank you, Mr. Beard.
We need a reset while he goes over his plea papers.
Say again.
We need a reset while Mr. Schmidt goes over the rest of the pleas.
Recess or reset?
Recess.
Recess, okay. All right, court will stand in recess.
I probably said reset.
Oh,
Plea papers.
I got it.
Are you ready on Mr. Schmidt?
Mark Thomas?
Thomas?
Yes, sir.
Right, this is cause numbers CR 25-17, 18, 123, and 124, State of Texas versus Mark Aaron Thomas. Show that we're set for arraignment on the latter two. Are we doing a plea on the first two?
Judge, we were, the state indicted those latter two very recently, so they postponed the plea offer, give us an opportunity to look at, the whole package.
You want to reset to July 1?
Yes, sir.
Any objection from state?
No objection, Your Honor. Thank you.
All right, have you had access to the indictments for arraignment purposes on CR 25-123, the theft of property, and the CR 25-124, possession of controlled substance, Mr. Schmidt?
Yes, sir. We understand the charges in both causes. We'll wait for more reading and a plea of not guilty to those at this time.
All right, court finds that Mr. Thomas, having waived the formal requirements of arraignment, court does enter his plea of not guilty into the record for each cause. Court sets Mr. Thomas for pretrial hearing in the latter two cases, July 1st at 1:30, 9 a.m. if he makes bail, and we'll carry the other two on docket calls.
The rest are pleas, Judge. I guess you can go through your queue and do them as you see fit.
Okay. Let's start with Demetrius Benson.
Come on down.
All right, this is cause number CR 24-125, State of Texas versus Demetrius Turner Benson. Mr. Benson, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Mr. Benson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes, sir.
Do you have any questions about anything that you have read and signed today that's part of your plea agreement?
No, sir.
Mr. Schmidt, do you believe Mr. Benson to be competent to enter into a plea agreement? And have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
Mr. Benson, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 grams, less than 4 grams. That does carry a range of punishment should you be convicted and sentenced to not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court consider the evidence, not convict you today. They're asking the court to place you on community supervision for 4 years, along with a $1,500 fine, $290 in court costs, and $605 in reimbursement fees, and $180 in restitution. In addition, there is an unfiled possession of marijuana, less than 2 ounces, that the DA's office is agreeing to resolve with your plea in this case. Mr. Benson, is that your understanding of the plea agreement?
Yes, sir.
All right, then, Mr. Benson, how do you plead to possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams?
Yes.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
The stipulation is admitted and the court takes judicial notice of Mr. Benson's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement today. The court hereby defers a finding of guilt, places Demetrius Turner Benson on deferred community supervision for 4 years, orders him to pay a $1,500 fine, $180 restitution, $290 in court costs, and $605 in reimbursement fees. And the court takes into consideration and dismisses cause number DA 2022508, possession of marijuana less than 2 ounces. Mr. Benson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll meet with the probation officers.
That myself.
Right, Mr. Glidewell. This is cause number CR 24-306, CR 25-75, CR 25-76, State of Texas versus Joshua Allen Glidewell. Mr. Glidewell, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? And it didn't come through on my end. Can you say that again?
Yes, sir.
Thank you. Thank you, Mr. Glidewell. You can lower your hand. All right, Mr. Glidewell, you are Joshua Allen Glidewell, is that correct?
Yes, sir.
And Mr. Glidewell, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes, sir.
Do you have any questions about the plea agreement that you've read and signed today?
Okay.
Mr. Schmidt, do you believe Mr. Glidewell to be competent? And if so, have you explained to him his rights regarding this case and all of the other cases that you've represented him on, and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Glidewell, I see here that on your charges, you appear to be pleading guilty pursuant to a plea agreement to cause number CR 25-75, aggravated assault with a deadly weapon. Aggravated assault with a deadly weapon is a second-degree felony. It does carry a range of punishment of not less than 2 years in prison, not more than 20 years in prison, and a possible fine not to exceed $10,000 should you be convicted. It appears that as part of the plea agreement, the state is recommending the court to consider the evidence, not convict you, place you on 6 years of community supervision, order you to pay a $1,500 fine plus court costs and reimbursement fees and restitution in the amount of $150. It appears that you are also going to be attending the substance abuse felony punishment facility as a condition of community supervision. And the DA's office is asking the court to consider and dispose of a violation of bond or protective order, an injury to a child, elderly or disabled individual, and also a criminal mischief between $100 and $750. Mr. Glidewell, is that your understanding of the plea agreement?
Yes, sir.
All right, let me ask you at this time, how do you plead to aggravated assault with a deadly weapon?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim contact. Victim impact statement was sent out and not returned.
Thank you, Mr. Hartwell. Anything further from the defense?
No.
All right, court is going to consider the evidence. Right, the court having considered the evidence finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. Court hereby defers the finding of guilt on the second-degree felony offense, aggravated assault with a deadly weapon, places the defendant on 6 years community supervision, orders him to pay a $1,500 fine, orders him to attend SafeP as a condition of community supervision, orders $150 in restitution, $290 in court costs, $520 in reimbursement fees. Further, the court dismisses under section 1245 cause numbers CR 25-76, a violation of a bond or protective order, CR 24-306, injury to a child, and cause number 2025-280, criminal mischief. Mr. Gladwell, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with the bailiff, and then after that, probation will give you more information. Mr. Crutcher? All right, this is cause numbers 2025 213, 214, 215, and also cause number CR 24-302. State of Texas versus Christopher Edward Crutcher. Mr. Crutcher, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you, sir. You can lower your hand. All right, Mr. Crutcher, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, Your Honor.
Have you ever been diagnosed with a mental condition?
No, sir, Your Honor.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work that he's done?
Yes, sir, Your Honor.
Do you have any questions about any of the paperwork that you've read over and signed today?
No, sir, Your Honor.
Mr. Schmidt, do you believe Mr. Crutcher to be competent to enter into a plea agreement? And if so, have you explained to him his rights regarding this case?
Yes, sir.
All right, and it appears to me that he will be pleading guilty in cause number CR 24302, which he was originally indicted with a third-degree felony offense of assault of a family or household member with previous conviction. It appears that his plea would be to a lesser included Class A misdemeanor assault causes bodily injury of a family member. And the other cases would be 1245. Is that correct?
That's correct.
All right, Mr. Crutcher, a Class A misdemeanor carries a range of punishment of not more than 365 days in the county jail and a fine, if imposed, not more than $4,000. I see that your plea agreement is upon your plea of guilty to the lesser included offense of Class A misdemeanor assault causes bodily injury of a family member. The DA's office is recommending that your punishment be assessed at 101 days confinement in the county jail, with you receiving credit for all 101 days, a $100 family violence fine, and the other matters will be dismissed under Section 1245 of the Texas Penal Code with your plea in this case. In addition, you will be responsible for court costs of $270 and reimbursement fees of $585. Mr. Crutcher, is that your understanding of the plea?
Yes, sir, Your Honor.
All right, at this time, I'm going to ask you, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Guilty, sir.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir, Your Honor.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, as for the criminal mischiefs that are being 1245 state is in compliance, restitution documents were sent out to the victims and were not returned. As for the assault family violence, state is in compliance as well. There is a victim impact statement. I'm not sure if that was sent to the court. If not, I can work on getting the court a copy of it before we finish up here. Essentially, though, Your Honor, victim stated in the victim impact statement that she doesn't want to proceed with the case, that getting Mr. Crutcher charged was not her intent. So state is in compliance and victim would be in agreement with the time served offer.
All right, thank you, Mr. Harwell. No, I've not received that, so if you can forward that to the court, I'll get that signed and circulated back to you. Anything further from the defense, Mr. Schmidt?
No, sir.
All right, then the court's going to consider the evidence. All right, the court has considered the evidence, finds enough evidence to convict the defendant of this offense. The court does follow the plea agreement. The court convicts Christopher Edward Crutcher of Class A misdemeanor assault causes bodily injury of a family member, sets the sentence at 101 days confinement in the county jail, awards Mr. Crutcher 101 days credit for time served, orders him to pay a $100 family violence fine, $270 in court cost, and $585 in reimbursement fees. The court also dismisses under section 1245 all causes outlined in the judgment of conviction by the court. All right, Mr. Crutcher, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released, if you're not able to pay your fine, reimbursement fees, and court costs all at once, then you need to report to the district clerk's office and speak with them about entering into some kind of payment arrangement so that you can pay those fines and fees. Failure to report and pay could result in you being arrested for a capias pro fine and failure to pay. And then you come back and you sit in jail and we have more hearings. Okay, you understand?
Yes, sir, Your Honor.
So make sure you take care of that.
Yes, sir, I will.
All
Thank
right,
you.
please, you're welcome. Please step over to be fingerprinted. Mr. Schmidt, give me just a second to sign these.
Sure.
Mr. Hartwell,
Yes.
I'm sure Ms. Abney's watching, but the modifications that we've made to the trial court certification are good. The little check boxes, that's a nice feature to have. So I'm glad y'all were able to get that done.
Yes, sir. I'll make sure to pass it along just in case.
About Mr. Ibarra.
Sir.
This is cause numbers CR 22-161, CR 25-88, State of Texas versus Joshua Andrew Ibarra. Mr. Ibarra, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Joshua Andrew Ibarra, is that correct?
Yes.
Mr. Ibarra, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you've read and signed today?
No.
Mr. Schmidt, do you believe Mr. Ibarra to be competent? And if so, have you explained to him his rights regarding the case?
Yes, sir.
All right, Mr. Ibarra, you are charged in cause number CR 25-88 with failure to comply with sex offender duty to register for life annually. I see that the plea agreement recommendation from the DA's office is upon your plea of guilty, they're recommending that the court set your punishment at 8 years confinement in prison. They're asking the court to suspend that sentence and place you on 5 years of community supervision. along with a $750 fine plus court costs of $290 and reimbursement fees of $520. In addition, they are willing to dismiss cause number CR 21-161, which is another failure to comply with sex offender duty to register for life. Mr. Ibarra, is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Ibarra, how do you plead to that offense?
Guilty.
Are you pleading guilty because you are in fact guilty of committing that crime?
Yes.
And you understand that the range of punishment for that third-degree felony is not less than 2 years in prison, up to a maximum of 10 years in prison.
Yes, sir.
And has anybody threatened you, forced you, pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. Right, is Mr. Ibarra going to be is he going to be supervised here in Texas, or I see in the stipulation there's some talk about Oklahoma? Is he
Yes, sir. Gonna be in Texas.
to be in Texas? Okay. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation. The DA's office, the court convicts Joshua Andrew Ibarra with failure to comply with sex offender duty to register. A third-degree felony, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice. Further, the court will suspend that sentence and place the defendant on 5 years community supervision. Court orders him to pay a $750 fine, $290 in court costs, and $520 in reimbursement fees. In addition, the court does dismiss cause number CR 21-161, failure to comply with sex offender duty to register. Mr. Ibarra, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll meet with the probation department.
Yes, sir.
Mr. Williams? All right, this is cause numbers CR 21-200, CR 24-193, State of Texas versus Michael Scott Williams. Mr. Williams, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Michael Scott Williams, correct?
Yes, sir.
And Mr. Williams, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes, sir.
Mr. Schmidt, do you believe Mr. Williams to be competent to enter into a plea agreement today? And if so, have you explained to him his rights regarding the case?
Yes, sir.
All right, and this appears to be a motion to adjudicate. Is that also correct?
That is correct.
All right, and does your client waive the formal reading of the state's motion?
Yes, sir. We wait.
And does he intend to plead? I guess there's only one count, so he'll be pleading true to count one.
Yes, sir.
All right, Mr. Williams, you did appear before the court on August 10th, 2021. You pled guilty to the second-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 between 1 grams and 4 grams Court heard the evidence, found that there was enough evidence to convict you, but the court followed a plea agreement on that day. The court followed the plea agreement and placed you on 6 years of deferred community supervision and assessed a $2,000 fine. It was during that period that the state filed a motion to adjudicate and revoke your community supervision, and they alleged a single or sole count of a violation. Have you had enough time to review that with your attorney, Mr. Schmidt?
Yes, sir.
Okay. At this time, Mr. Williams, I see that the plea agreement is upon your plea of true to that sole count. The DA's office is recommending that the court consider your plea of true, and then for the court to adjudicate your guilt. That means to find you guilty, to revoke your community supervision, assess your punishment at 10 years confinement in prison, and then they're asking the court to suspend that sentence today and place you on 6 years of community supervision and order you to pay the balance of your financial obligations, which appears to be a $2,000 fine and $875 in reimbursement fees. In addition, they're asking that you conduct a substance abuse evaluation, follow those recommendations, and that you were to serve 180 days confinement in the county jail, for which you will have credit for those 180 days for various dates that you have served that time. In addition, the DA's office is willing to ask the court to dismiss an indicted assault causes bodily injury of a family or household member by impeding breath or circulation. Mr. Williams, is that your understanding of the plea agreement?
Yes, sir.
All right. At this time, I would ask you, Mr. Williams, how do you plead to count 1 in the state's motion? Is that count true or not true?
Sure.
And you're telling me that it's true because what is alleged is in fact true.
Yes, sir.
And has anybody threatened, forced, or pressured you to plead true?
No, sir.
All right, the court accepts the defendant's plea of true to count 1. Mr. Schmidt, any objection to the court admitting the defendant's waiver of rights and plea of true into evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just in the 1245 assault family violence, state is in compliance and the victim is in agreement. She had indicated to the state that she didn't want to proceed on that case, knowing that that case would end in this result. So she is in agreement.
Thank you, Mr. Hartwell. Mr. Schmidt, anything further?
No, sir.
All right, court hereby finds that the defendant has violated the terms and conditions of his community supervision. Court finds count 1 to be true. Upon that finding, the court will follow the plea agreement and recommendation of the DA's office. The court convicts Michael Scott Williams of manufacture delivery of a controlled substance in penalty group 1 between 1 grams and 4 grams, a second-degree felony. Court assesses punishment at 10 years confinement in prison. Court suspends that sentence, places the defendant on 6 years community supervision. Court orders him to pay the balance of his financial obligations. Court also orders him to undergo a substance abuse evaluation and follow all recommendations thereof. Court also orders him to serve 180 days confinement in the county jail, for which credit is given. The court dismisses cause number CR 24-193. All right, Mr. Williams, it looks like you're going to have another opportunity to serve a sentence in the community. I hope you understand that this will not be a revolving door in this court.
Sir.
So if you violate any of the terms and conditions, and it's proven to this court after due process, that means you have a hearing and you have an attorney if you can't afford one. You understand what happens?
Yes, sir.
And what is that?
I go to jail.
For how? No, you don't go to jail.
Prison.
You go to prison for how long?
10 years.
10 years. That's your agreement. You said that you will go to prison for 10 years if you violate it. You understand?
Yes, sir.
All right. You're hereby remanded to the custody of the probation department. I'm going to have you step over to be fingerprinted. After that, the probation officers will tell you about what's next. Mr. Abraham, let's see, who else do we have?
I think that finishes.
Is that it?
Believe so.
Mr. Smith moved very efficiently today. Thank you, sir. Appreciate your hard work.
Yeah, you're welcome.
Thank you, Mr. Hartwell. Thank you, Mr. Hernandez. Appreciate your work.
Thank you, sir.
All right, that does conclude the court's criminal docket today. The court is adjourned.
Thank you, Your Honor. Bye-bye.
You're welcome.